Good evening. Welcome to the evening edition of From Day One. We'll pick up with the no nonsense judge and the soft-set idiot.
A sworn statement.
Where's what?
A sworn statement. I have a right to see a sworn statement saying I injured someone.
There's a complaint in the file.
Sworn complaint, signed, all
You want to see it?
affidavit, sworn affidavit.
No, it's not. I don't think it's an affidavit.
Well, okay, so
You said you wanted a sworn complaint.
from an injured party. Who have I injured for the record?
The state of Michigan
How can I
are
injure the
bringing the
state?
charges.
How can I injure the
Sir,
state?
sit down. Sit
I prefer to stand.
down.
I'm not.
Sit down, or I will hold you in contempt.
Another threat. Wow.
You're probably going to hear more than one.
I see.
Do you though? Because all I see is a judge who's tired of dealing with a dick flute, and a dick flute is about to do some jail time because he won't sit down and shut up.
All right. I am ruling that I have jurisdiction. You are free to appeal that to the circuit court. Proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge, the people are prepared to move forward. Just as a quick preliminary matter, we'd request a mutual order of sequestration with an exception for the
So-
OIC.
All right.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay, all right, and would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
she's a witness. She is a
I-
witness.
Sir, you speak again when I haven't asked you to, and you're in contempt, and we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you, so I'm asking you to state your name. Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
I said I object. What am I supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Okay, well, you still owe me $100.
You
Can
still
we all
owe it.
just take a moment to leave a comment of appreciation for judges like Judge Oakley, who are experts in helping the fuck arounders find out?
Are you going to give me your name? That's fine. Thank you.
Oh, don't give the name. That way he's going to have you in there too.
Your Honor, the people call Officer Steppen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611B, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of
Bless you.
probable cause conference. And I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause.
This is a problem. This is a preliminary exam.
This is, okay, so right here.
This is the probable cause hearing.
It says.
All right, stop. Right now, the question on the table is, you've objected to admittance of that document. I want to know what your legal objection is.
I'm also objecting.
What is your legal objection?
To not waiving my probable cause hearing.
Denied. That's admitted.
Under what
I don't have anything to say except good job, Judge.
grounds am I denied not?
Because
Am
you
I-
Denied.
didn't have a valid objection.
I object.
You can't just object. You got to explain with the valid
I
objections to the
object
evidence.
that we are having a preliminary exam when I haven't had a probable cause hearing and that I did not.
They're the same thing,
It's
Mr. Michaud.
still, on this. it
Mr.
doesn't-
Michaud,
it
they're the
doesn't-
same thing.
But it's still, I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference. And today is a different date that says a preliminary.
Have you
exam.
ever had a grilled
If it
cheese?
was different,
Have you ever had a grilled cheese?
if it was different, why would it have two?
Have you
separate
ever had a
columns?
grilled cheese?
I object to any of that. Why would it have? two
You
separate
object to a
columns?
grilled
Take
cheese
him out.
sandwich?
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not going to let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be, and what I have also represented to him regarding that objection. Mr. Michaud, I think the court record will reflect, had a probable cause conference first on November 29th, and then again on December 20th. I have disclosed, I think I've been very transparent with Mr. Michaud that probable cause conference is a bit of a misleading name, because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we did.
I understood to be his wishes. I may now understand differently that I misrepresented him in some way, but my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether discovery.
You don't have to tell me what they are. I know what they are.
I know, but I'm just trying to explain.
And I'm trying to explain it to him too, but I'm not going to talk over him.
Right.
And I'm not going to play that crap today.
Right.
So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that. But you got to be quiet while I'm talking. Clear?
Oh, dude, I hear you.
All right. The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today. That is a probable cause hearing. Probable cause conference is just a name that we all came up with instead of saying it's a pretrial for a felony. Do you have any questions based on that?
At what point did I waive it?
We're literally dealing with a living brain donor. If you would just listen to what the judge is saying, you would understand. A probable cause conference is nothing more than a meeting where a conversation would take place. Now, a probable cause hearing, which is what you're bitching about being forced to waive, is actually occurring today. So you haven't waived shit. I swear. They should give court orders to people like you to carry a planner around everywhere you go, just so you can make up for the oxygen you're stealing from the rest of us.
Because if it's a hearing,
You didn't
right,
waive it.
so
There's nothing to hold.
Do I have a right to have a probable cause conference?
No.
What?
You can do that right now. Do you want to make a deal with the people?
I want to be able to prepare myself for the probable cause conference.
There's no preparing for a probable cause conference. It's a
it's-
conversation.
It still takes preparation.
You want a PCC? Go out in the hallway, have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this stage.
There's your PCC. Now, do you want to plead guilty? Do you want to have an exam? And at the exam, he's got to prove to me those two things I just said. Probable cause to believe a
I love that. You want a PCC? There's your PCC. The state says they have no offer. That's it. That's what happens all the time.
crime was committed on this date and reason to believe that you were involved. Do you want to have that hearing so he has to prove his case? Or do you want to waive? That's the other option. You can waive the preliminary exam and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a felony, where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Michaud has made his arguments today, he ruled on his arguments, and that he preserves his right to.
He can appeal them.
As you've already said, at circuit court. So if he wants to sort of move forward on that defense alone, that, you know, the waiver does not preclude him from
Not at all.
arguing jurisdiction at the circuit court level. But likewise, if he holds a preliminary exam today, holds the people to that burden, he also maintains the right to continue his objections to jurisdiction, to appeal the court's orders regarding jurisdiction at that next level, at the circuit court level, assuming that the people are able to prove probable cause today.
Now, do you want to have an exam today?
Well, I wanted to address some, I served the court some notices.
I haven't read any of that because you were represented by counsel.
No, I wasn't. I don't have any contract.
As far as I knew, you were represented by counsel.
Okay, so now you know. And I served the court notices. And I would like to.
First notice, what would you like to put me on notice about?
Well, I served you notice that I requested the criminal bonding information. I requested
Criminal what?
bid bond.
Hold on.
I
What?
requested the bid bond, the performance bond. I have the affidavit.
There is no bond.
There are bonds. This is
Okay,
you said it's criminal.
listen. You can't tell me something and then just disagree with me
Well,
and think
okay.
listen to me, sir. I am not going to let you interrupt me.
No, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black robe, okay? That's just the way it works. My courtroom, I get to decide how it's run.
Now that is how a judge should run their courtroom.
There are no bonds required for me to do what's scheduled today. I've been doing this 25 years. I've never had a bond.
You have a bond.
Okay, I have a bond.
Everyone
I
here
don't-
has a bond.
Not in any definition I know. So let's get to the point. Do you want an exam today?
No, I really want to address. Okay, so
I'm not addressing any of that crap you
Can
got in
you-
front of you.
well, since you say you don't have a bond, can you express that in via affidavit so I can have
It's on the record. Order a transcript. I'm not signing anything for you.
Okay. Also, I want to also address that. I sent affidavit of fee schedules for violation of any of my rights.
There are no fee schedules.
Well, I gave you notice and.
Great,
you haven't-
then you gave me notice. Doesn't change anything. We still scheduled for an exam today.
Yes, just put it on the record that I served you notice, okay? Also, I served you notice on my power of attorney.
Okay, you
Okay.
said that.
Right, and
Move on.
you haven't responded to that, as well as my indemnity bond, which separates me, and I have a private capacity. I am not the artificial person.
I don't
am not
recognize
a
any of that.
United States citizen. I am
Stop,
actually
hold on,
identified.
stop. You can put on notice what you sent the court if you want to make a record of that. But I'm telling you, I don't recognize any of that stuff you're talking about. I don't recognize that you're not really Frank Michaud. Okay, I understand that's what you're trying to argue, but I don't
Under
recognize that.
Under what law could you represent or you can use, tell me that, not just from what you say, because ignorance of the law is no excuse for you or nobody else. So what you're saying just don't